Hello everyone, Keith here, and I'm back with part 3 of this BRUSHABER versus Union Pacific Railroad court case. I'm here with part 3. I'll leave the link down in this document description below. If you want to email us, donate to us for our PayPal or email down description and millions@gmail.com. We do private consultations and stuff like that. So anyway, I'll finish up with part 3 and let's get right into it. 2. The Act provides for collecting the tax at the source. That is, makes it the duty of corporations, etc., to retain and pay the sum of tax on the interest due on bonds and mortgages, unless the owner to whom the interest is payable gives a notice that he claims an exemption. This duty cast upon corporations, because of the cost to which they are subjected, is asserted to be repugnant due to the process of law as taking of their property without compensation. And we recapitulate various contentions as to discrimination against corporations, such as against corporations and against individuals, predicated on provisions of the Act dealing with the subject. A. Corporations indebted upon coupon and registered bonds are discriminated against as corporations not so indebted are relieved and of any labor or expense involved in deducting and paying the taxes of individuals on the income derived from bonds. B. Of the class of corporations indebted as above stated, the law further discriminates against those which have assumed the payment of taxes on their bonds. Since although some or all of the bondholders may be exempt from taxation, the corporations have no means of ascertaining such fact, and it would therefore result that taxes would often be paid by such corporations when no taxes were owing by the individuals to the government. C. The law discriminates against owners of corporate bonds in favor of individuals, none of whose income is derived from such property, since bondholders are, during the interval between the deducting and paying of the tax on their bonds, deprived from the use of money so withheld. D. Again, corporate bondholders are discriminated against because the law does not release them from payment of taxes on their bonds, even after the taxes have been deducted by the corporation, and therefore, if after deduction the corporation should fail, the bondholders will be compelled to pay the tax a second time. E. Owners of the bonds, the taxes of which have been assumed by the corporation, are discriminated against because the payment of the taxes by the corporation does not relieve the bondholders of the duty to include the income from such bonds in making a return of all income, the result being a double payment of the taxes, labor, and expense in applying for a refund, and the deprivation of the use of the sum of the taxes during the interval which elapses before they are refunded. The provision limiting the amount of interest paid, which may be deducted from the gross income of corporations for the purpose of filling the taxable income, to interest on the indebtedness not exceeding one half of the sum of the bonded indebtedness of the paid up capital stock, is also charged to be wanting in the due process because discriminating between different classes of corporations of individuals. 4. It is urged that want of due process results from the provision allowing individuals to deduct from their gross income dividends paid by them corporations whose incomes are taxed, and not giving such right of deduction to corporations. 5. Want of due processes is also asserted to result from the fact that the Act allows a deduction of $3,000 or $4,000 to those who pay the normal tax, that is, whose incomes are $20,000 or less, as not allowed the deduction to those whose incomes are greater than $20,000. That is, such persons are not allowed, for the purpose of the additional or progressive tax, a second right to deduct the $3,000 or $4,000 which they have already enjoyed. And a further violation of due processes is based on the fact of the purposes of the additional tax, and the second right to deduct dividends received for the corporation is permitted. 6. In various forms of statement, want of due processes is moreover insisted arising from the provisions of the Act allowing the deduction for the purpose of ascertaining the taxable income of stated amounts on the ground from that the provisions discriminate between married and single people, and discriminate between husbands and wives who are living together and those who are not. 7. Discrimination and want of due process result, it is said, from the act of the owners of houses in which they live are not compelled to estimate the rental value making up their incomes, while those who are living in rented houses and pay rent are not allowed, making up their taxable income, to deduct rent which they have paid, and that they want in a due process also results from the fact that although the family expenses are not, as a rule, permitted to be deducted from gross to arrive at taxable income, farmers are permitted to omit from their income return certain products of the farm which are susceptible of use by them for sustaining their families during the year. So far as these numerous and minute, not to say in many hypocritical contentions, are based upon assumed violation of the uniformity clause and their want of legal merit as they want apparent, since it is settled that clause exacts only a geographical complaint of Nullington versus Moore, Flint versus Stone Tracy, and Billings versus United States. So far as the due process clause of the Fifth Amendment is relied upon, it suffices to say there is no basis for such reliance, since it is equally well settled that such clause is not a limitation upon the taxing power conferred upon Congress by the Constitution. In other words, that the Constitution does not conflict with itself by conferring upon the one land a taxing power and taking the same power away on the other by the limitation of the due process clause, Street versus White, Prenton versus Brandy, McCrae versus United States, Flint versus Stone Tracy Corporation, and Billings versus United States, and no charge in the situation here would arise, even if it be conceded, as we think it must be, that this doctrine would have no application in the case where, although there is a seeming exercise of the taxing power, the act complained thereof, there was no arbitrary as to constrain the conclusion that it was not the extortion of taxation, but a confiscation of property, that is, taking of the same violation of the Fifth Amendment, or what the equivalent is thereof, was so wanting in basis for classification as to reduce such a gross and patent, the Fifth Amendment, or what's the equivalent thereof, in equality as to invariably lead to the same conclusion. We say this because none of the propositions relied upon the remotest degree present such questions. It is true that elaborately insisted that, although there be no express constitutional provision permitting it, the progressive feature of the tax causes it to transcend the conception of all taxation and to be mere arbitrary abuse of power which must be treated as wanting in due process. But the proposition disregards the fact that in the very early history of the government, a progressive tax was imposed by the Congress, and that such authority was exerted in some, if not all, of the various income taxes enacted prior to 1894, to which we have previously adverted, and over and above all the contention, but disregards the further fact that its absolute want of foundation in reason was plainly pointed out by Nullington versus Moore, and the right to urge it was necessarily foreclosed by the ruling in that case was made. In this situation, it is, of course, superfluous to say that the arguments in this exponentially of levying such taxes, or the economic mistake or wrong involved in their imposition, are beyond justicial conveyance. Besides this demonstration of the want of merit in the contention based upon the progressive feature of the tax, the error in the others is equally well established, either by prior decisions or the inadequate basis for classification which are apparent on the face of the settled provisions. That is, the distinction between individuals and corporations, the difference between various kinds of corporations, Flint versus Stone Tracy, Billings versus United States, Bank versus Kentucky Wall, State Deposit Corporation versus Steed. In fact, comprehensively surveying all the contentions relied upon, aside from the erroneous construction of the amendment, which we have previously disposed of, we cannot escape the conclusion that they all rest upon the mistaken theory that although there will be differences between the subjects taxed, to differently tax them transcends the limit of taxation and amounts to want of due processes. Where a tax levied is believed by one who resists its enforcement to be wanting in wisdom and to operate in justice. From that fact, the nature of things arises a want of due processes. From that fact, in the nature of things, there arises a want of due processes of law and resulting authority in the judiciary to exceed its powers and correct what is assumed to be mistaken or otherwise exertions by the legislative authority of its lawful powers. Although there be no semblance of warrant in the Constitution for so doing. We have not referred to a contention that because certain administrative powers enforced that were conferred by the statute upon the Secretary of its Treasury, therefore it was void and unwarrantedly delegating legislative authority, because we think to state the proposition is to answer it. Marshallfield and Corporation versus Clark, Butterfield versus Stranahan, Oceanic Steam Naval Corporation versus Stranahan. That's about it. Thank you guys for watching. I'll see you guys in the next video. Like, subscribe. I'll leave this document in the description below. And once again, our email is down in the description below. It is themullings@gmail.com. If you want to PayPal us, you can PayPal us for consultation, private consultation, and stuff like that. And yeah, I'll see you guys in the next video. Have a nice day. Bye, everyone.